address the points or some of the points. I mean, I think the first issue is why have we not made a declaration in terms of 34.6, in terms of the protocol on the African Human Rights Court. And I was interested, Colette, in your inputs. I have to say I'm not in agreement with a lot of them, but let's sort of see what you think of what I'm going to say and what other people think. Also, just to say to Dr. Nkata that the 8 states, as I understand it, that have made the declaration, that the 8 includes Rwanda, so it's 7 without Rwanda. Is it 8? I've got Burkina Faso, Malawi, Mali, Tanzania, Ghana, Cote d'Ivoire, and Benin. I don't know if there's anybody, and then it was Rwanda as being the 8th one.
Yeah.
Was the Gambia red? Oh, okay. Okay. All right. But anyway, those are the states that have made the declaration. The concern, basically, as I think that Colette correctly said, is concerns over, I mean, our sovereignty. Remember that in South Africa we are a bit unusual compared to other countries in the world in that we have an additional layer of appeal which comes from our historical background. You know, usually countries would have a high court and then an appeal court. We have, in addition to that, we have a constitutional court. So in addition to the Supreme Court of Appeal, or what is now the Supreme Court of Appeal, you can still then further go to the Constitutional Court. So that's a different level. The reason we have that is because during the transition there was an acceptance that all the judges could remain. But then there was a view that there should be a new court to adjudicate on the Constitution. So we already have more layers, I think, than anyone else, or more layers than most people. I'd be interested if anyone can tell me whether there is any other country which has 2 layers of appeals. Sorry? Sorry? That's domestically, yes. So basically what the effect, as I understand it, of the declaration would be is that people can then go to the African court as a further appeal body. I think there's also a concern relating to, well, the constitutional courts and our courts would adjudicate in terms of interpretations of the Bill of Rights. The African court would be adjudicating in terms of the Chapter 1 of the African Charter, and they're different. And there are some different values there as well. So, for example, issues which are quite contentious on our continent relating to LGBTI rights. What would the African court, how would they adjudicate? There's a specific section in the chapter relating to the family, which is usually where disputes come in. Is a family a man and a woman, or do you have other forms of only, or do you have other forms of families? But there would be those kinds of issues. We've seen that it's often people opposed to transformation that take matters up with international bodies. So Solidarity and AfriForum have taken up issues relating to their perceived discrimination with the Committee for Elimination of Racial Discrimination. And sorry? In Geneva, yes. Would they be taking, and our courts have after some time, I think, reached a framework relating to affirmative action, what is permitted, what isn't. Affirmative action is something that other people sometimes from outside South Africa find difficult to understand because it goes against equality, but it's because of addressing historical imbalances. So, you know, I would be a bit cautious about other people adjudicating on issues like affirmative action, and definitely I'm sure people like Solidarity and AfriForum would be going there if we made such a declaration. Also, there's issues of, I mean, there's one noticeable difference with the African court compared to the European court is that individuals and NGOs have to, I understand it, in the European court demonstrate that they're direct victims of human rights violations, which anyone, as long as they're from Africa, can bring a case in the African court. There's also the issue of the selection process for judges. I mean, it was interesting that Judge Weke referred to, I think it was a Ugandan judge being reappointed. Our court, since the Honourable judgment, the former Chief Justice, the Constitutional Court judgment, have been quite adamant that people in senior positions cannot be reappointed if that position is one or they cannot have their terms extended. So, for example, in the case of the former Chief Justice Honourable, that the President at the time couldn't extend his term of office as Chief Justice. That's been then extended to the NDPP and other senior officials in the National Prosecuting Authority. Because of this problem of, currently the documentation is a judge is appointed for a maximum of 6 years, they can be reappointed for 1 term. But the problem with the reappointment, what you have to do to get a further term. And effectively they are elected by secret ballots by members of the Assembly. There's no specification for qualifications. So effectively these are people who are going to overrule our Constitutional Court. So those are really the concerns relating to the issue of ratification. I'm a bit surprised and would want to engage more with Colette over where you said some of the decisions in South Africa should be tested outside. I mean, which are those? Then we come to the Malabo Protocol, and why have we not ratified that? And look, I think Professor Viljoen has dealt with some of the problems. The inconsistency with the immunity issue, which we opposed in the negotiations, I understand, the immunity to heads of state. The issue that it doesn't deal with the relationship between the Rome Statute and the Malabo Protocol. And other sort of inconsistencies on the issue of the crimes. What are those crimes? The illicit removal of mineral resources, I think it is. So those are all problems that we've got, I mean, from a legal opinion on ratifying the Malabo Protocol. Now, we do have from the ruling party a resolution that we should be ratifying the Malabo Protocol. But we can't ratify it as it is. And as everybody knows, it's 15 states that have ratified, that have signed, and none have ratified. So we've been trying, we then embarked on a process of engagement with the AU Commission with the aim of amending or reviewing the Malabo Protocol. In September 2017, at the 5th meeting of the Open-Ended Committee of Ministers of Foreign Affairs on the International Criminal Court took place at the AU Permanent Observer Mission to the United Nations in New York. We attended the meeting. The meeting considered whether the committee should undertake a campaign for the ratification of the Malabo Protocol. The meeting was of the view that there was a need to look into the reasons why member states were neither signing nor ratifying the protocol, and to consider the reasons for the poor ratification, as well as considering the possibility of adopting revisions or amendments to the protocol taking into account the concerns of member states. We received last year in July a note verbal from our mission in Addis requesting that a questionnaire on the Malabo Protocol be completed and submitted, which we did. However, a subsequent note verbal was received indicating that the AU Commission has extended the deadline for the submission of the questionnaire to the 15th of August, as only 2 member states responded to the questionnaire. We haven't, I think, had anything more since then. But basically, the process then to be followed in dealing with the problems of non-ratification was to ask states why you're not ratifying. The uptake, I'm not sure if this figure, the officials from my department assure me that it is, or that that's all they're aware of only 2 states responding. So it's then difficult as to how far we will, where to take it from now. But bottom line, we can't ratify as it is. We support the issue of an African court, but the process for amending the protocol hasn't even really started. Then to come to the ICC, and it is an area of conflict. Why? Because, as we've said before, the ICC is not the court we signed up for. And one can go into a number of problems with it. The lack of participation of 3 of the 5 permanent members of the Security Council. The powers of the Security Council, even though 3 of the 5 are not members of the ICC. The fact that effectively the court has only prosecuted people from Africa. And it doesn't seem to be much of an uptake on other cases. I mean, you had wars in Libya against Africa, but involving, but what I'm specifically referring to is the role of NATO countries, for example. Nothing. Iraq, Afghanistan, Palestine, yeah, but effectively only African countries prosecuted, and problems with partial prosecution, selection, non-selection, and perception. The prosecutors similarly twice refused to open an investigation into Israel's 2010 attack on the humanitarian aid flotilla bound for Gaza, bringing her into direct conflict with the pretrial chamber, which has disagreed with her assessment. Similarly with Afghanistan. So those are the problems. We do have, again, from the ruling party, a resolution that South Africa should withdraw from the International Criminal Court. And hence the attempts were made to withdraw. The declaration that was lodged, though, was ruled as incorrect by, I think it was the Gauteng High Court. Because it didn't involve the parliamentary process, an international crimes bill has been tabled in Parliament together with further notices of withdrawal. All of that has lapsed. The intention currently is to revive that international crimes bill, but to subject it to public input, to public comment. As I said, we are, it's not for any member of the ANC to decide they're not following a conference resolution. It needs to be followed, but in the process of and stop tapping so much, Prof. Luciana, I can see you moving your hand. But in the process of implementing that resolution, if there are issues that come up in the public hearings, we would need to basically go back to the ANC, the party that got the electoral mandate that sent us there, to basically reevaluate. So I'm not sure if you're clear at what I'm saying. I mean, look, basically from a personal perspective, I mean, the ICC is not perfect by far. We're in a world that is multilateralism is increasingly under threat from America, from other countries as well, Brazil now, but it's the only court we've got. So personally, I would believe that we need to look at addressing the problems within the ICC. Just to also say that there are other gaps, or even if the decision not to withdraw from, or the decision to withdraw from the ICC is reversed, there are other aspects, other gaps in our law. We don't have jurisdiction, apart from some crimes under the Terrorism Act, we don't have jurisdiction to try crimes committed in other countries. We also have a problem of we can extradite to the ICC, but we can otherwise only extradite to, as far as we know, and there's an issue currently which we're having to deal with, and the legal opinion is being sought, but our understanding is we cannot extradite to other international tribunal, which is a change that should be made. So, for example, if the tribunal on Rwanda were to want somebody extradited to them, we would, as we understand it, not be able to legally. It may be useful to amend the law to allow that to take place. The only international body we can extradite to currently is the ICC. So look, I was meant to be watching my watch. I've got 3 minutes. Oh, okay, so I thought I'd gone over. But I think I've largely said what I'd wanted to say, which was addressing the declaration, the non-ratification of Malabo, and where the process is, and then lastly the process with the International Criminal Court. So currently we are still a member of the International Criminal Court. We have, as I said, a ruling party resolution, which we cannot ignore. The idea would be to subject the International Crimes Bill to a public participatory process, to revive it in Parliament, and to see where the process takes us from there. Let me stop there, I think.
Thank you.